If a judge fails to inform a defendant about the mandatory fines at the plea, is the sentence subject to vacatur? To find out, you have to read People versus Juan Padilla-Zuniga. But it's 3 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Juan Padilla-Zuniga, published by the New York Court of Appeals on March 18th of 2025. The citation is 2025 New York Slip Opinion 01563. And the issue in this case is whether the court's failure to inform a defendant about the mandatory fines related to a conviction renders that conviction reversible, as a product of not being knowing and intelligent and voluntary. To understand and appreciate the context of this case, the background that's helpful to know is that, first of all, a plea must be intelligently, knowingly and voluntarily entered into, and it's the judge's responsibility to ensure that any plea is intelligent, knowing, and voluntary. And to do that, when a plea is given, when a plea is accepted or taken by a defendant, the judge has to allocute the defendant at the plea stage to make sure that they're not on drugs, they understand what's going on, they understand all the terms, that they have had proper representation. There's a variety of things the judge has to cover to ensure that a plea is properly taken by a defendant. The other thing you have to know is that there's something called a waiver of right to appeal. And typically with a plea bargain offered by the prosecution, that usually involves a requirement that the defendant waive the right to appeal. And it waives a lot of different things, but it does not waive if a plea is knowing, intelligently, and voluntarily entered into. And the last thing you have to know is that certain convictions involve mandatory fines. For example, VTL 1192-2A, which is aggravated DWI, aggravated driving while intoxicated, or driving while intoxicated by the alcohol. There's a mandatory fine attached to that conviction. You're not allowed to take a plea to that conviction without also agreeing to take that fine, to pay that fine. The same thing with VTL 511, which is aggravated unlicensed operation of a motor vehicle. The statute actually includes that any conviction involving that crime must include a fine, minimum of $500. And so what are the facts in this case? The facts are that in this particular case, the defendant, Juan Padilla-Zuniga, was charged with aggravated unlicensed operation. That's VTL 511, aggravated DWI, which is VTL 1192-2A, and leaving the scene of an accident. The charges stem from an incident in which the defendant allegedly operated a vehicle while under the influence of alcohol and without a valid license. He then pled guilty, right? He took a plea bargain, which included the waiver of right to appeal. And the plea was that in exchange for a sentence of 5 years probation, he would plead guilty to these things. As well as, so that's what the judge allocated him to at the plea bargain part of the stage, and allocated him that he was knowing, intelligently, and voluntarily entering the plea. But when it came time for sentence, the judge didn't just give him 5 years probation, gave him 5 years probation and the mandatory fines that are required by the statute. The defendant did not object to the sentence, but he appealed and said, wait a second, the judge sentenced me not just to what I agreed to at the plea, but to these fines which were never discussed and agreed to by me at the plea. And he said that his plea was not knowing and intelligent and voluntary because the plea, when he allocated, it did not include an understanding that he would be paying these fines, even though they're required by the statute. The appellate division, upon appeal, affirmed the conviction and said, wait a second, these are mandatory fines. And the issue was not preserved. The defendant didn't appeal, didn't raise this. He didn't object at sentencing and say, wait a second, I didn't agree to pay these fines. So they said it was not objected to, it was not preserved, and there's a waiver of right to appeal, which prevents this kind of appeal. The defendant appeals to the Court of Appeals, and they reverse. The holding here is that the defendant's plea could not have been, it was not knowing, intelligent, and voluntarily entered into because he was not informed on the record by the judge of the mandatory fines prior to sentencing. So it couldn't have been knowing, intelligent, and voluntary. The court emphasized that a waiver of right to appeal is effective for a lot of different things, but it's not effective to preclude a defendant from challenging the voluntariness of his plea. So they vacated the plea and they remitted the case for further proceedings. They sent it back. But ultimately, the holding in this case is that the judge failed to inform the defendant of the mandatory fines. But that's a problem that can void the entire plea and sentence. And that's the case of People versus Padilla-Zuniga. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.